喺度。有冇同學有 assignment 喺度？我醫科嗰個，我醫科嗰個 assignment 有冇人有？未 download 未 upload 上去。未 upload 上去。OK。但係就知道 deadline 嘅時間。係。我唔記得咗係12、17係啦，12、17即係完晒個 course 之後成個月，咁即係大把時間啦。反正都係最後嗰幾日先做嘅，唔係咩？我唔知邊陣，我要問翻先。交嗰份呢個 system 係啦，睇緊佢嗰條應該係比較係要做啲 research 係同我嗰啲嗰個 approach 唔同，即係同我嗰啲 fashion 嗰類嗰個 approach 唔同。佢嗰啲呢個 system 嘅通常要即係要你自己 search 啲嘢，或者冇一個一定嘅答案。但係我啲就係 problem based 即係純粹係揾個 solution 出嚟。可能我最後一堂先同你哋講分下三句，反正都仲有即係完咗最後堂都仲有成1個月先點解。咁我就嗰堂先講。同我哋有個 vision class， 不過係幾月後，係好搞嘢。4月如果冇記錯嘅話。係啊。最重要係 for exam。係啊，咁到時先講人上。太耐啦，其實我覺得呢個 arrangement。因為你到時唔記得晒，其實最好就係 revision class 係隔，我覺得係隔2-3個禮拜最理想。咁你有時間消化晒你，因為你每個禮拜2-3堂嘅時會逼啲，即係可能你聽咗一大抽嘢，你又未大著晒。咁最好係俾你消化下2-3個禮拜學晒 revision 就最理想。但係幾個月咧太耐，你會唔記得咗？即刻上，其實比較好。即刻又唔好，最好係2-3個星期。要根據我嘅經驗，2-3個星期學晒最理想。public 同埋 private 嗰個咧，同 guarantee 間公司唔係派落去嘅。因為你留意啦 ，private 有3個 restriction， 50個 members， 50個 shareholders， 唔可以去 public 嗰度invite 一個 investment。咁同埋佢 transfer shares 咧係有 restriction。咁呢兩樣嘢根本同 guarantee 冇關，係咪？有冇留意到根本係唔係同佢一個唔相關？咁而佢另外嗰50個人咧，佢用 members 同埋嗰個 shareholder 嗰時咧，佢都冇講過係話 guarantee， 係啦，所以其實佢係唔包括咗。即係 private public 個 concept 同 company limited guarantee 係唔係一個 related 嘅 concept。即係 private 同 public 係變一個有 share 嘅公司。所以佢冇 private public 嘅 concept， 喺 limited guarantee 裏面嘅。private 同 public 係有 share 嘅公司。你記得佢個 restriction 就係話你唔可以係 public 佢認為 share， 就唔可以叫人。唔可以冇限制嘅選手 shares， 但係呢乜大張先冇嘅，你有冇留意佢 restriction 根本同佢冇關？所以係即係另外你可以當佢 isolate 咗一類嘅嘢。佢冇 model answer 嗰啲啊。 嗰本嘢嗰個 question 唔係我，不過我可以俾少少，RC特別唔係好似唔係好似嗰個後面嗰啲佢係想你 refresh 你個 memory， 即係你睇完之後佢想你快咗明。係 exam question， 到時我會講，但係唔使太緊張。你即係你中意揾我，同埋唔好花太多時間睇本書度，我覺得。始終你會拉人咧，中意書。因為我出㗎嘛 exam question， 我都係主要係要拉人。即係 lecture notes 裡面講過嘅嘢有機會考，我上堂講嘅嘢都有機會考。書裡面嘅嘢得，因為係多個需要嘅嘢，嗰本書係多過我哋需要嘅嘢。只不過佢學校想俾多啲資料你，係啦。其實你某一個 area， 當你聽完之後，你可能想知多啲，咁你可以去睇下，你可以再睇下，或者你3文時你覺得需要多少資料，你可以再睇。但係本身嗰本書係多過我哋需要考嘅嘢。我亦都唔覺得係成本要諗緊，即係我覺得你喺呢個 stage 裏面，即係 even 你係想個 learning 嘅 purpose， 或者你想考好成績嘅 purpose， 我都唔覺得你要諗晒嗰啲嘢。因為考好成績嘅話，我已經講過，我主要係靠個 lecture notes 裏面嘅嘢，我上堂講嘢。唔係你嘅考試得2個鐘，你睇好多嘢你寫唔到，你冇辦法寫唔到，所以反而個 analysis 你 concept 清楚嘅時候。我成日問你哋要 clarify concept 嗰類咁嘅嘢咧，就會好緊要 ，structure 會好緊要，但係唔係需要好多 information 報翻出嚟睇翻下先。另一樣，如果你純粹係 learning purpose， 我覺得喺呢個 stage 裏面，其實你聽晒明我講嘅嘢，同明呢個 lecture notes 嘅嘢已經足夠。到時如果你真係要接觸某一個 area 咯，你到時再先睇會更加好。咁呢個咁但係當然你話你好中意睇，咁當然都考係當然都考。即係唔好太大 pressure， 就同本書一定高估晒所有嘢。有啲同學話我要一定要明啊，咁佢好緊張，即係唔需要咁，唔明啊啫。點會第一次就唔會再？有啲我都唔記得啦。有時你問我唔係熟啲嘅，但係你即係個 main theme 嗰度你 follow 咗，到時先揾㗎嘛。你 law 都係，律師都係咁，佢唔會記得晒所有嘢，但係你個大原則你要知。in case 到時你真係有嘢嗰時，你喺嗰個 area 你咪再揾，即係去 research 嗰個 area， 就知得到個答案係咁樣。所以唔好把握關係，即係話操場唔好把握，卡都幫埋，冇卡都幫埋，所有嘢又都要數清晒佢，係錯㗎。無論 learning 同考試都係錯㗎。呢個我覺得總之我覺得係你聽得晒明我上嚟 lecture notes 就基本上明白，我唔講喺度，基本上明白點解考試真係個 performance 就係考你個分析同埋你嘅 conceptual understanding， 同埋你嘅表達能力。因為字幕係咁，你係寫唔到嘅，你識好多嘢你都寫。 Okay, maybe we start the class. So before we start lecture 4, I want to talk about the assignment first, right? You don't yet have the assignment. Okay, so maybe we wait until the last lecture. Then I'm going to talk about the assignment. I'll give you some hints, the general rules, the guidelines, how to get a good grade in the last lecture.
But you want to know the question.
But you don't have the question yet, right?
Yeah.
So I'll remind the office, so they upload to you sooner. But I'm not responsible for all the administrative stuff. The question already here. I said the question already, right? So the question already here, but I don't know. I suppose you already have it, but you don't. I'll remind them, right? So don't worry too much. You keep checking your internet account. I think you will have it very soon. But anyway, because we still have time, you have more than a month to do your work, even after the last lecture. Because you only need to submit. I mean, deadline is on 17th of December. So you have a whole month to do your work. So don't worry too much, right? I think that you have time, right? You have time. So let's talk about the assignment on the last lecture. And we have a revision class on April, a few months later. So only in the revision class, we talk about the examination, right? So now we focus on the learning first. Okay. Let's try to refresh your memories on what you learned in the previous lecture, all right? So what we learned in lecture 3. What we learned in lecture 3, I know you still remember. It's not really difficult.
Company. How to
Of course, company, right? Yes.
create a company.
How to establish a company. Yes, then how to do it.
Article, subject, form.
One single word. So you can sum it up. The whole thing. Registration, right. Registration, right? So don't mix up a company with partnership and a sole proprietor. When you want to run your business as a sole proprietor, what you need to do, nothing, right? Because you can do it immediately. You are the vehicle. Because as a human being, you can run the business. Because you can sign a contract. You can get the payment, right? You can pay someone. And you can do all the obligations stated in the contract. So nothing you need to do. So how to form a partnership? Well, a group of people, they agree on something. Then you form a partnership. And you can form a partnership immediately. Because a partnership is a relationship. And a sole proprietor is yourself. But how about a company? You need to do something. There's one thing we call registration. Because you need to submit the forms, right? The incorporation forms and the articles. But that is actually registration, right? So company being formed by registrations. And so how about the nature of a company? Or how about nature of partnership? If you have a partnership, do you need to aim for something particular? You must aim for a profit, right? So I'm not saying that you have to make a profit. It doesn't make sense. But you must aim for profit. So you cannot form a partnership for what? Charity, right? It's not possible. Because by definition, you are not having a partnership. You want to do charity. All right? So 保良局, the Guideline Association, it cannot be a partnership by the definition of law. All right. So how many kinds of company you can form? 5 different kinds, right? So we don't have to memorize everything, but we have to understand the key concept here. What I mean by private, what I mean by public, right? What I mean by limited. Limited, it means what? Limited liability, right? And unlimited, what I mean by unlimited? It means unlimited liability. Private, public, limited, unlimited, and what? Company limited by guarantee, right? Guarantee means you don't have members. You don't have shares. You don't have shares, right? You don't have shares. All right. So roughly, that's what we learned in lecture 3. Okay. So let's talk about lecture 4. We are going to learn a very important legal principle, right? Very important legal principle. We call separate legal entity. Very important. If you ask me one question, what's the most important legal principle in company law? I would say this one. right, concept or principle of separate legal entity. But before that, before I explain to you, I want to ask you a question, right? With a very short story here. So what happened here? So Albert and Bobby, right? We have two parties. They are the only shareholders and directors of a company named Dry Pool Limited. So it suggests something in Cantonese. Gontong, it means what? Not having enough cash, right? Anyway, you have the right to choose your company name unless this is offensive or illegal. But I don't think this one is offensive, right? It's just very sad, right? But not offensive, not illegal, right? For those who cannot understand Cantonese, dry pool somehow means not having enough money, right? Okay, so we have a company here, and Alice and Bobby, they are shareholders and directors. So the company borrowed $1 million from the bank, but failed to pay on time according to the loan agreements. Well, very simple situation, right? Not very complicated. I want to ask you one question. Do you think that the bank can sue Albert and Bobby? Why not? Why not? Yes or no? No, right? The bank cannot sue Albert and Bobby. It means the bank can only sue
The company.
the company. But why? Why? What kind of information is spotted from the story here?
Limited.
Limited, right? So limited, it suggests that limited for what?
Liabilities.
Limited liability. All right. So for a company limited liability. So you think that the company cannot, the bank cannot sue Albert and Bobby. Of course, your answer is correct, right? But can I argue something like this? Because Albert and Bobby, they are the only shareholders, and they are the only directors of this company. So in substance, do you remember something we call forms and substance, right? That's always the concern of the court. Forms mean superficial, right? On the face of it. Substance, it means what actually happened. So if I'm the lawyer of the bank, can I argue something like this? Because Albert and Bobby, they are the only shareholders, and they are the only directors. So it means that in substance, they have complete control of the company, right? If Albert and Bobby, they are just one of the many shareholders, they only hold 1% of the shares, right? Or if Albert and Bobby, they are not directors of the company, and they only hold 1% of shares of the company, then they don't have any interest to this company at all. So I think that will not be any problem. They are not responsible for the debt of the company. But can I argue that because they are in complete control of the company, and that they are the only shareholders, right? So they hold 100% of shares, maybe 50-50, right? 50-50. Albert and Bobby, they are also managing the company. Try to remember the definition of shareholders and directors, what we learned in the previous lecture. So as a shareholder, you are the owner of a company. So you own the company, right? As a director, you manage the company. So on one hand, you own the company. On the other hand, you manage the company. And there are only two parties here. So you are in complete control of this company. Am I correct? From the operational sense, right? From the operational sense. So from the operational sense, they are the company. So you are the lawyer of the bank. Can I argue that? Because you are in substance controlling the company. So you cannot evade your liability. You have to be responsible for everything. And I can sue you. Do you agree with an argument like this? Do you think that an argument like this will be accepted by the court? Yes or no? So if Albert and Bobby, right? If Albert and Bobby, each of them only hold 1% of shares, or Albert and Bobby, they hold 50 and 50. It means in aggregate 100, right? Do you think there any difference between scenario 1 and scenario 2? Can I argue that in scenario 2, Albert and Bobby, they have to be responsible for the debt of the company because they are in complete control. But in scenario 1, they don't have to, but they only hold 1% of the shares, right? They are minor shareholder, and also they are not directors. Can I argue like this? Yes, you can argue like this, right? I can argue like this. No, wrong, right? Wrong. No matter in scenario 1 or scenario 2, Albert and Bobby, they don't have to be responsible for the debt of the company. And the outsider, the bank, can only sue the company regardless of their ownerships or their status as a director, right? So this is the answer. But why? So this is the most important concept in modern company law. And I hope that, so all of you can bear in mind. Very important. If someone, say something like this, remember, that is nonsense, right? That's nonsense. I don't care of your shareholding. You hold 100%, 90%, 50%, 10%, it doesn't matter. Because we have a very important legal principle in company law, and that's what we call as concept of separate legal entity, right? Separate legal entity. So make a guess. We got the doctrine. It has an even higher status as a principle, a doctrine, right? 原理，他們有個原理 more than just a principle. It is very important, overwhelming, right? Overwhelming. Why? Or what it means? So the doctrine of separate legal entities, the most important concept in modern company law. So under this doctrine, a company is a legal person, right? Be careful, listen carefully. It's a legal person, 法人, right? Legal person. Independent and separate from members and directors. So once a company being incorporated, right? Once a company being incorporated, that company become a legal person, right? Legal person, completely independent from the owners and from the directors, and also separate from the members and directors, all right? Very important concept. So we don't have to worry about the shareholding behind. If you hold 90% of shares of a company, or even you hold 100% shares of the company, still you don't have to worry about your liability if you hold a company limited by shares. So if anything wrong with the company, for any kind of liabilities being incurred by the company, only the company will be sued. And you can only sue the company, but not the guys behind, all right? That's what we call as concept of separate legal entity. So where does it come from? Of this very important legal principle? Our common law system, of course, right? Because we have a case. So we have a leading case here. So a very old case, but this case still prevailing. In this case, still the authority that we can rely on. Under the echo. Yes. Okay. It's a very important case, right? Very important case. And this case we call the Solomon case, right? Solomon case. So what happened in this case? Not really complicated. So someone running a shoe business, right? Selling shoes as a sole proprietor, right? As a sole proprietor. So later on, he incorporated a company where he was the major shareholders, and then the remaining shares, only a few percent, belong to his wife and other family members, right? So shoe business. Later on, Mr. Solomon incorporated a company, and then, right? And then he transferred it, he sold all the business to this company, right? He incorporated a company and then sold his own business as a sole proprietor to this company, right? So that's what happened. Unfortunately, The three businesses subsequently declined, and the company went into liquidations. Liquidation means temple being terminated, right? Of a failing business. The remaining fund of the company not enough to repay the debt. But if the money remain incapable to settle all the debt, nothing will happen. Right? No one cares how you handle a company, right? Because everyone gets paid. But the problem is the remaining fund not capable to settle all the debts. So the liquidator, all right, liquidator, 清盤人, it means the one responsible for the writing process, responsible for the liquidation. You're going to learn about it in the last lecture, all right? The liquidator. So the liquidator try to argue that Mr. Solomon, you hold the company, you and your family member hold the company, own the company for 100%, right? For 100%. So you are still in substance, control the company. So it means that the business still belongs to Solomon and so to the debt, right? So this was the argument by the liquidator. Because you own everything, right? You own 98% of the shares, and your wife and your children own the remaining 1 or 2%. And you're also a director. So you control everything, you own everything. So even the business is being sold from yourself to the business, but in substance, right? The liquidator tried to argue, in substance, come on, you're still the same, right? You're still the same. So if you are the same, then the debt of the company still belongs to you, and you cannot escape from it. You get the point here. But if the debt only belongs to the company, so during the liquidation process, if the company cannot settle the debt, then the company will be terminated, and that's all. And Mr. Solomon himself is not responsible for anything. But if the argument of the liquidator are being accepted by the court, then Mr. Solomon still have to be responsible for the debt. If the court accepts the argument that if you hold the company for 100%, then it means that you are still the company, right? If that argument being accepted by the court, then Mr. Solomon will be in trouble. So very important, right? So very important. At first, the trial court held that the company was simply an agent of Solomon. As the first trial, right? At the first court proceedings, the court held that the company was simply an agent. You already learned about agent or agency. So it means that, right, in the eye of the court, the company was something being appointed by Mr. Solomon to handle his own business. It means that, right? It means that the company, not actually running a business. Try to recall the definition of agency. In an agency, the agent represents the principal to negotiate contract, but the contract actually belongs to the principal, right? So if the company only an agent, so it means all the contracts signed by the company actually belong to Solomon. So do the debt. So the debt also belongs to Mr. Solomon, right? And the court accepts this argument. So therefore, the business still in substance belongs to Solomon, and he also needs to be responsible for the company debt, right? Something like this. So I don't know whether Mr. Solomon really looked like him. I just make a guess. Wow, I don't know. And that will not be examined. It doesn't matter. But take a look at the figures here. So this guy, Mr. Solomon, he holds 20,000 shares. Belong to him 7 shares. Belong to his wife and children. It means that, right, Mr. Solomon and his family members in complete control of this company. And that's why the liquidator tried to argue that because you are in substance controlling the company, so you are still the company, and you have no difference with the company. So you have to be responsible for everything. So he loses the case in the first trial, but he appealed, right? He appealed. He appealed to the House of Law. House of Law, something like the Court of Appeal in Hong Kong. a higher court. So he appealed to the House of Law, and the court held that it's a very important judgment here. So normally I don't quote the judgment, but I try to do a summary for you, right? But the judgment here is really good. So I want to have you, the raw materials, so you can take a look, right? So normally I do the summary for you. So take a look, very important, word by word. The company is at law a different person altogether from the subscriber, it means the founders. At law, a different person altogether, right? So it may even be that after incorporation, the business precisely the same. The business precisely the same, exactly the same thing after incorporation. The same person are the managers, just like the case of Solomon. And the same hand received the profit. But so what? The company is not in law the agent of the subscriber. No, right? No. So it doesn't matter. Even everything remains the same after incorporation. For example, if we are not studying law here, we are studying business management. So before or after incorporation, from operational sense, from the management perspective, any difference? Nothing, right? If we are studying MBA here, if we are not studying law, right? From the management perspective, from the business perspective, exactly the same, no difference. But the court held that even everything remains the same, just because of the incorporations, you created a new person here. The company is something new, entirely separate, entirely different from the founders, right? So this kind of argument will not be accepted by the court. So don't waste time, right? Don't waste time to argue that you are still the company, because after incorporation, everything remains the same. This kind of argument will be rejected by the court, all right? No, because of the Solomon case. So the court rejected the idea that the company is only an agent. No, absolutely not, right? Not an agent. The incorporation process gives birth to a new and separate legal person. And the independence was firmly upheld by the court. Remember, right? The last sentence, very important. Despite the ownership might be the same as before, right? Regardless of the memberships. So it doesn't care, right? It doesn't matter. So no matter the ownership is 1%, 40%, 50%, 51%. So don't be misled by the members. Don't be misled by the numbers, right? 40%, 50%, 51%, 60%, 75%, 99%, even 100%. No difference. The company is a separate legal person, regardless of the ownership. So the guy behind the company, the person owns the company, and the person manages the company, they are not the same as the company, right? And that's a very important legal principle from the Solomon case. So I hope that everyone, always remember the Solomon case and the principle of separate legal entity, all right? Then what are the implications? What are the implications of this legal principle? We just learned about the concept of separate legal entity, but we have to, and probably that's even more important, we have to understand the implication, it means the impact, right? What will be the impact of this legal principle? Number one, independent authority. Based on this principle, right, we understand something. Independent authority, a company can exercise all the functions like a natural person legally. So that's why we call company as a legal person. Separate legal person, right? Fine. So don't mix up with the term being used in mainland, 法人代表 legal representative, right? So that's an entirely different concept in mainland. Right? Legal representative 法人代表 in mainland China means that person legally represent the company, right? But legal person in the common law system, in our legal system in company ordinance of Hong Kong, it means a company can act like a person, like a human being. Legally speaking, of course, right? So it means that, well, what are the legal capability of a human being? As a human being, legally speaking, what you can do? What are your legal rights? You can sign a contract, of course, right? As a human being, you can sign a contract. You can own property, of course, right? You can own a property. You can own a piece of land. You can own an apartment. You can own a car. You can have a bank account. And then think about a company. Do you think a company can sign a contract? Yes, of course, right? Do you think a company can own properties? Absolutely. And that's what we say independent authority. Because a company, right, is separate, right? It's separate. It's a legal person. We created a legal person after the incorporations. And a company can function like a human being from the legal perspective, of course, without the biological function, right? Except for the biological functions. So a company can be, simply perform everything, just like a human being. So a company can also be sued, right? Can be sued. And a company can sue someone, right? A company can be a plaintiff. You know the term plaintiff, right? 原告人. So a company can sue someone. A company can be a plaintiff in a civil case. So number one, independent authority. A company may also subject to certain criminal offenses, right? Some of them. Another one, separate liabilities, right? Well, this one probably is the most important. Whenever you think about the incorporation of a company, right? Separate liabilities. So the liabilities of a company are not the liabilities of the members, and vice versa. The principle holds, even the company is fully owned by a single member. Very important. The liability of the company belongs to the company, regardless of the ownership of the member. So even that person holds 90%, 99%, or even 100%, the liability of the company still belongs to the company, never to the member, right? Even the company only have one single member, the principle still holds, right? No difference. So you don't have to worry about it. So even you own a company and you are the only shareholder of this company, you can still use the company to sign a contract. So if anything wrong with the company, you will not be responsible for it. The third party can only sue your company, but not yourself, which in law is completely different, right? Completely different. So another one, separate liabilities. Last one, separate right. So very interesting. What I mean by separate right? So think about it. Again, right? Again, from the business sense, well, it sounds very ridiculous. Because number one, the members can conclude contracts with the company. The member can sign a contract with the company. And even you are the only member, and even you are the only shareholder, you can still sign a contract with your own company. I mean, what happened? Your right hand and left hand sign on the same piece of paper, right? It sounds very silly. On the right hand, you are Edward. And then on the other side, you also sign Edward, but on behalf of ABC Limited, right? Can you do so? Absolutely, yes, right? So you can sign a contract with right hand and left hand. So again, right, again, from the management perspective, it's nonsense, right? Because there's, same person. But in company law, it makes sense, right? And you have the right to do so. You can sign a contract with your own company. So why you have to do this? Is it silly? No. It always happens. Why you sign a contract with your own company? Can you think of any special reason that will be sensible to sign a contract with your own company? It's a very practical issue here. Can you employ yourself?
Yes.
Yes. For tax purpose, right? How about can your own company borrow money from you, and then you sign a loan agreement with the company? Yes. Right? Yes. So in case the company cannot repay, I'm serious, right? You can do so. So in case the company cannot, if you incorporate a company, right, you are the only shareholder, and you use your company to run the real business, retail, right, or wholesaling, anything. If your business is being failed, your company also borrow the money from the bank. So the bank want to sue the company, and you can also be one of the plaintiffs to sue the company. So you can sue your own company, and based on contract signed between right hand and left hand, right? That's absolutely allowed. Allowed, right? You can do so, right? You can do so. There are many case law, to support that, right? And this kind of arrangement that's allowed in company law, in law. So you can conclude contract with the company and then enforce the respective right against the company, despite the ownership, right? You don't have to worry about your ownership. Because I'm the major shareholder, because I'm the only shareholder, don't worry about it. Because the company is separate from you, right? Even you are in control of that company, the company is still separate from you. But on the other hand, right? On the other hand, a company can also sue the member. Yes, right? Absolutely. Even you are the only shareholder, the company can still sue you. So we just learned about the basic, right? So all these things, they are the basics. We try to illustrate this principle by referring to different cases, because this principle is really important. We try to understand the concept of separate legal entity from different, perspective, right? Different scenarios, different factual situations. So number one, we try to interpret the separate legal entity principle from the employment perspective, right? So think about the impact on employment. So what happened in this case? Mr. Lee, right? Mr. Lee. So he was the major shareholder, director, and chief pilot of an aviation company. So this person having 3 different status, right? As a major shareholder. Major shareholder normally means you hold more than 51%. So 51% is a magic number in a company with shares. I explain to you later, right? So 51 is a magic number. 75 is another magic number. Right? They are magic numbers for the corporate lawyers, right? So major shareholder normally means he hold more than 51. So somehow he's in control of this company. But he's not the only shareholder, right? So only a major shareholder, but not the only shareholder. And he's also a director, one of the director. And he's also chief fellow. It means that he's also an employee, right? So he's a shareholder, director, and employee of this company. Okay, something bad happened because he was killed in one of the fire missions, right? So he was killed, and you know that as an employee, if you get killed in your work duties, you're entitled to compensation, right? We don't go into details because that will be employment law, right? But just a common sense, you know that when you get killed, right? You're entitled to employment compensations. As an employee, compensation as an employee. So Mr. Lee said, well, I want to sue the company on the basis that the company has statutory liability to compensate the employee, right? He wants compensation. Remember, Mr. Lee is only one of the major shareholders, but not the only shareholder, right? And one of the directors, but not the only director. So there are some other directors and some other shareholders. So we have to decide on a very important issue. The issue here was whether Mr. Lee was a genuine employee of the company, right? Because the other directors and other shareholders, they disagree, right? They disagree. They disagree on the ground that Mr. Lee was not a real employee. Why? Because he signed a contract with himself between right hand and left hand, right? He signed the contract on the right side as a director of the company, and on the left side as an employee of this company. So the other directors and the other shareholders, they reject the request, right? They turn down the request of his wife by arguing that, well, come on, that's nonsense, right? It's nonsense. You're not a real employee. We only compensate a real employee, and not you are not, right? Your husband is not, right? He's not a real employee here. I think you know the answer. Right? I think you know the answer. So I mean, this argument, it sounds logical, right? Without legal training. If you ever study law, right? If you don't know about Solomon case, then probably you tend to believe that it is logical, right? Because Mr. Lee really not looking like a real employee. So think about that. Sign a contract between right hand and left hand, right? But because of the operation of the Disarmament Principle, so let's take a look at the judgment. Number one, the court realized that, so Lee is the major shareholder and director. Okay, fine, right? I know, right? The judge held that, yes, I know, I realize that. But the court still maintained that Mr. Lee was capable to enter into a contract with the company. Why? Because the company by itself is independent from the owners. And the ownership and your status as a manager will have no impact to this legal principle, because this legal principle is very key. A company, once being incorporated, is separate. So even you sign a contract between right hand and left hand still work, right? So the application of the way of Mr. Lee being allowed by the court, right? So the company need to pay compensations to Mr. Lee as an employee, all right? The first case. Let's take a look at the judgment. So really good. So I quote the judgment here. Right? Normally I don't do it. The first paragraph. The relationship came from the fact that the deceased was one legal person willing to work for and make a contract with the company, which was another legal entity, right? So the status of a company as a separate legal entity once being stressed by the court, which is prevailing, right? Overwhelming. Number two, the contractual relationship shall not be invalidated even the deceased was the sole governing director and he was in control of the company, so what, right? He signed a contract with himself, but so what? This is allowed, right? Because the company is separate. That's what. So unless the company is shrunk, it means something fake, right? Not real. So otherwise, the capacity of the company to make a contract with the deceased could not be prejudiced. It means, as a company, you have, it's perfectly legitimate to sign a contract, right? Even with yourself. So that's what we learned from the Lee versus Lee Air Farm Limited, from employment perspective, right? Regarding the operation of the Disarmament Principle. So let's take a look at another case. Another case, we try to understand the same legal principle regarding ownership and interest. So what happened in this case? So a person, right, owned a timber, right? You know the woods, right? The woods. He also insured the timber with his own name, right? With his own name. He owned it, and he insured the timber with his own name. This is normal, right? So the owner later on sold the timber to a company, which he was the controlling shareholder, right? A little bit like the previous case. Right? Controlling shareholder, not the owner shareholder, but controlling shareholder. So he sold it, right? He sold it. So the company owned it somehow by himself. again, right? Unfortunately, a fire broke out and damaged the timber. For George, right? For me. A fire broke out and damaged the timber. And then the person here tried to claim for the compensations from the insurance company. Because he told the insurance company that I'm the one to insure the timber, right? So I pay for the insurance policy. My name's still on it. So now the fire broke out. I am entitled to the compensations. But the insurance company refused to pay him because the timber was owned by the company at this present moment, and he had no insurable interest on it. But that's another principle in insurance. When you try to insure something, when you try to claim for it, then you need to have insurable interest, right? So how the court think of it? The court held that in order to have insurable interest in the property, a person must have ownership, right? If you want to claim compensations, you must be the one who owns that thing, right? That asset, that timber. But under the principle of separate legal entity, who own the timber? The company own the timber, but not the shareholders. So the company shall be the one to claim for compensations. But this person, right, this guy, I don't remember his name, he still trying to argue that, no, I own the company. I'm in control of the company. So in substance, no difference, right? I control the company, and the company own the timber. So you just pay me, that will be fine, right? You just pay me, right? No, rejected by the court. So again, I call something, right? I call a judgment from the court here. So very good, right? Very good judgment. So sometimes I mean the judgment, they're really difficult to understand. Some of them, because the judge they're very learned, right? Because I can't say anything back to the judge. That would be contempt of court, right? And someone complained to the bar association, I will get disqualified. So no, right? I cannot make any negative comment on the judge, but because they're so learned, right? So they like to show off the language skills. So sometimes they will be very difficult to understand their judgment, right? They're all graduated from Oxford and Cambridge, right? So sometimes they will be very difficult to understand and to follow their judgment. But the judgment here are very good and easy to understand. We know the first paragraph. So number one, it's clear that the appellant had no insurable interest in the timber. Because what? Because the timber belongs to the company, right? Not to that person, number one. So you own all the shares in the company. And the company also owns your money. But neither as a creditor or shareholder, you don't have any right to insure the company asset. Last one, most important, right? The key issue here is relationship was to the company, not to the goods. So you think about it, something like this. That person, right? That person. So you own maybe 51% of the company, and then the company owns the timber, right? So the court tried to clarify the conceptual understanding here. Remember, I don't know, maybe Mr. Lee, right? Remember, Mr. Lee, you own the company. The company owns the timber, but you don't have any ownership to the timber because of separate legal entity, right? You own the company owns the timber, but you don't have any ownership to the timber because the company is separate from it, all right? So very important concept. One more case, right? One more case. Another company. So we have a company, we call it GPD, right? Good Profit Development Limited. So what happened in this case? So a piece of land was owned by the company, right? Piece of land owned by the company. So GPD Limited. So owned a piece of land, right? So this company owns a piece of land. And there are two shareholders of this company, right? Only two shareholders. Maybe A and B, right? Two shareholders. Two shareholders own this company. And the shareholders here, both of them, promise the plaintiff to transfer that piece of land to him. It means to sell it, right? The shareholders agreed with the buyer, right? With the buyer on this piece of land. So it means that A and B signed a contract with the buyer regarding the piece of land. Because the shareholders told the buyer, so don't worry, right? I own the company. We own the company for 100%, right? We own the company, so don't worry. Don't worry, right? You just sign a contract with me and my friend here, right? We are the only shareholders. Then you can get that piece of land because that piece of land owned by the company, owned by us, right? So that's what happened. But later on, I don't know for whatever reasons, the parties here, they refused to sell that piece of land to the buyer, right? So the buyer wants to sue, of course, right? The buyer wants to sue based on a contract. So the buyer wants to sue A and B and also the company, right? So the buyer wants to sue three parties here. Anything wrong here? Any legal errors here? Any misconception here? When the buyer wants to sue A and B and the company, anything wrong? You just learned a very important legal principle, right? The principle from the solvent case. So anything wrong here? 呢個律師係咪做錯嘢？打屁屁 right? Something wrong based on the advice from a stupid lawyer. Because the lawyer suggested to the buyer, you can sue A and B and also the company. Anything wrong? Something wrong, right? Because of the Disarmament Principle. The company being separated from the owners. So, even a contract signed by the owners, and they are the only shareholders, they hold the company for 100%. But it doesn't mean that you have any contract with the company. And you only have a contract with the shareholders. But you don't have any contract with the company. So, I'm not saying that, right, be careful. So I'm not saying that the buyer is wrong in suing, to have a litigation or to sue someone, right? Nothing wrong. So my advice is that the buyer is entitled to sue the shareholders based on breach of contract, right? Because you agreed on something that you are not capable to do. You promise to procure the company to transfer that piece of land to me, and you fail to do so, right? You're going to learn about it in contract law later. That is obviously a breach of contract, right? Promise something and you're not capable to do, and you sign it on a piece of paper against you, right? But the wrong thing is that if you put the company as one of the defendants, that's wrong, right? That's wrong. I'm not saying that suing for your breach of contract is wrong. That's correct. But when you place the company as the third defendant, that is incorrect. So the court held that the company does not own the asset on behalf of the members, right? Not as a trustee, not as an agent for the company, for the shareholders. Because of what? Because of separate legal entity. That piece of land belongs to the company, right? Not to the shareholders here. So you sign a contract only with the members. You never have a contract with the company. So you don't have any right to sue the company. So I'm not saying that, right? Maybe finally, do you think that the buyer can still get that piece of land at the end? Yes, you can, right? So there's only one thing wrong. The company should not be a defendant in this case. You can sue the shareholders, and then you can get a specific performance order from the court, right? It means you get an order from the court, an order from the court to direct the shareholders. You have to procure this company to complete the transaction, right? So I'm sure that the buyer finally can succeed to get that piece of land. But the only thing being wrong is that you should not put the company as a third defendant in this case, right? The company should not be a defendant in this case because you don't have any contract with this company. Why? Because of the concept of separate legal entity, all right? Okay, so it seems like that, right? Actually, it is. It seems like that. Is it a good thing? Do you like the concept of separate legal entity? Do you like it? I like it, right? I like it. I really like it because it offers very good protections for the potential investors. So if we do not have such a concept, so that will be very risky to run your business, right? Because you have to worry about your ownership. If you are holding, too many shares of the company, then you have to be liable, right? If you hold 1%, fine, you don't have any problem. But if you hold more than 51, you hold 65, 7%, or 90%, then you will expose yourself to the risk of your business. Then it means that this is discouraging people for further investment, right? So normally that is not something good. So I like that, right? I like the Disarmament Principle. But you have to realize that the principle of separate legal entity offers very strong protection to the owners of the company, right? Of course. But remember, it may also be abused to avoid legal or legitimate obligations. So whenever there are gray areas here and the loopholes here, I can tell you that some bad lawyers, they will try to take advantage from it, right? But that's all about the money, right? They are giving very good advice to the client, and they can charge on a very handsome legal billing, right? So whenever there are gray areas, so someone try to take advantage from it. So this principle always being abused. So I mean, in general, it is good, right? For all the legitimate, for all the decent investors, for all the decent businessmen, nothing wrong, right? Nothing wrong. But think about the bad guys, because we are not living in a wonderland, right? We are not living in a utopian world. We are living in a cruel commercial world. And there are people always trying to take advantage from the gray area. So the law provides a mechanism to deal with this problem. And there's something we call the doctrine, another doctrine, right? Another doctrine. The piercing the corporate veil. Right? Piercing, it means get through it, get through it. The veil is something like the mask, right? Corporate veil. So what it means exactly? So it means that under certain circumstances, the corporate form, right, the separate legal entity, the company as a separate legal entity will be pierced. It means ignored. And then the liabilities of the company will be treated as the liability of the person behind. Oh, that's very good, right? So we try to catch the bad guys behind the mask, right? So don't think that you can cover up your bad things with the veil of a company, right? Because in certain circumstances, the court held that you have to be responsible. You are the bad guys hiding behind the company, right? So that's what we call the doctrine of piercing the corporate veil. Another very important concept in company law. We try to look at this picture. Because normally, because of the concept of separate legal entity, right? So we have a company here, and the creditors, or the outsider, or the bank, right? They can never sue the business owner, normally the shareholders. But because of the operations, you can argue, right? If the court accepts your argument or piercing the corporate will, then the corporate form will be ignored, right? Ignored. And then you can catch the guys behind the corporation, right? The bad guys. And that's what we call as piercing the corporate will, right? Another very important concept here. So what's the general principle regarding the concept of piercing the corporate will? So we have to look at a case, right? The court divided will work. So again, I quote the judgment and I highlight in paragraph 1. So the court will lift the corporate will of a company if it is a facade or a puppet of a controller used for fraud or to evade legal obligations and liability, right? So that's the general guiding principle. So exactly what it means, right? Exactly what it means. Number one, right? Number one, when there's special circumstances indicating that the company is a mere facade in considering the true facts behind. So it means that the company is not true, right? The company is a fake. You establish a company here, not because you really want to have a company, but because you want to cover up something, right? Number one, right? Number one. And then another one, and remember, right? When you understand the law, you have to be careful and hugely different, right? Different, and it means both. You need to have both elements, all right? Or it means either one. Different, right? Different. So what kind of boyfriend you want? A handsome guy, and also very wealthy, right? And or, right? And go sleep earlier, right? Have a good dream, you have everything, right? But or maybe you can, right? Can find a handsome boyfriend or a very wealthy boyfriend, I don't know. But anyway, you have to be careful, right? And it means you have to fulfill both conditions, right? So number one, when you form a company, and the only purpose in forming a company is to cover up something, and at the same time, what you want to cover, illegitimate, it means something illegal. Right? You want to cover up something illegal. Once we handle a case, a family law case. So normally I don't handle any cases of family dispute because I'm a corporate lawyer, right? So normally I don't. Most of the time I handle corporate cases, sometimes for commercial crime, but that's very rare to handle family cases. But it once happened. One party tried to argue that by using this concept of piercing corporate, in saying that a guy, right, in a family dispute, in the case of divorce, the wife want to argue that the husband used a company to cover up his expenses to his seabed girlfriend. Right. The wife tried to make an argument like this. Do you think that the court accepts? Use a company to cover up the expenses to his seabed girlfriend in their marriage, right? Because that guy spent a lot of money on that seabed girlfriend, right? A little fee, like 小三. Right. So he really set up a company to do everything. So the wife want to argue that, all this payment, that company, right, set up to cover illegitimate purpose. How do you think the court? Do you think the court agree or disagree with an argument like this? Well, I'm asking you a very serious legal question here. Not a joke, right? Not a joke. It really happened.
Disagree.
So think about the two conditions here. How do you think? Number one.
Yes.
Yes, right?
Yes.
I agree.
Yes.
Because that company being established for the sole purpose, only one purpose, to cover all the expenses to his seabed girlfriend. Right? Then think about number two.
No.
same old, right? I will, yes. The answer is no. The second condition cannot be fulfilled. Because we are talking about illegitimate. What I mean by illegitimate? Illegal, right? So when you have a wife, when you are in a marriage, and then you have a single girlfriend or two or more girlfriends, like that's a moral problem, right? I'm serious, right? That's a moral problem.
Yes.
You're only immoral. I'm not saying you're good, but immoral. Immoral doesn't mean illegal. So don't mix up. Right? Illegal is illegal. Immoral, another thing. Right? You have to be good to your parents. Right? Your parents raised you up, so you have to love them. You have to respect them. Right? So if you are not doing that, that's immoral, but that's not illegal. So no one can arrest you because you are back to your parents. Right? Because that's not illegal stuff. That's only immoral stuff. So remember, right? The general guideline is that when you want to raise the argument of piercing the corporate veil, so both conditions have to fulfill. So number one, you have to persuade the court that you set up a company, and the sole purpose to set up a company is to cover up something, and you never really want that company, right? But you only want to cover up something. Number two, you cover up something which is illegal, illegitimate, illegal, right? From the legal perspective, which is illegitimate, but not the moral perspective, all right? I mean, the threshold is very hard. And I have to remind you, even we have a weapon here, right? We have a weapon for piercing a corporate veil. It's a very powerful weapon. But I can tell you that this weapon will not be casually or easily allowed by the court. Right? It's just like a nuclear weapon. That's only the final solution, right? So normally, just like the country, right? The Russians, China or United States, they have nuclear weapons, but normally they don't dare to use it because that is only the last resort. And that will be the same for piercing and corporate veil, right? So we have such a principle here. But the threshold is really high. It means normally the court will be very reluctant to allow your applications for piercing and corporate veil, right? Very reluctant. Because normally they believe that you have the right to have a company in order to protect your legitimate interests. So you need to have very solid evidence in order to support your applications. So in real life, almost 95% of the applications to raise this concept, right, for piercing and corporate veil will fail in court. Right? This is very difficult, right? Very, very difficult. So I tried several times and almost, all my applications fail. Not because I'm not a good lawyer, right? I'm a very good lawyer, but that's really difficult, right? That's really difficult. I don't mind. I still get paid. I still get paid. You know our legal system, right? Unlike in U.S. Say like in U.S. You know how they call the lawyer in the United States? Evidence chaser. Right? Because they can share the compensation to the victim. But that is not the case in Hong Kong. We cannot share anything with our client. Right? We only pay on hours. So no matter you win or you lose, it doesn't matter to the lawyers, right? At least in theory, right? We still want, to win a case, of course, right? But the point is, we charge on hours. We don't pay on, not depending on the consequence. Right? So I don't, right? It doesn't really matter to me. But anyway, remember the threshold is really high, right? It means that will be very difficult in order to, get an order from court. Why so difficult? Number one. So never think that you can argue a subsidiary company being owned by the parent company. In this scenario, almost you can forget it. It means you cannot argue that I signed a contract, right, which is a subsidiary of Hong Kong Bank, right? We call it Kowloon Bank, right? We call it Kowloon Bank Limited. So Kowloon Bank Limited being owned by HSBC. So I signed a contract with Kowloon Bank Limited. So Kowloon Bank Limited breached the contract. So I want to sue. So I won the case. I get the judgment from court to award for an award for $1 billion. So the company not capable to settle my claim. So I want to argue that because this company being owned by HSBC as a parent company, so I use the concept of piercing corporate veil, and then HSBC need to pay me for getting it, right? No. So if you try to put forward an argument like this, I can say that you fail 99.9999%, right? Because that's already clearly denied by the court. A parent company to hold subsidiary company, it doesn't mean that they are the same party. Even 100%, right? Even a parent company hold 100% of subsidiary, because that's a normal practice. Well, if any of you work in a big enterprise, or if you work at a listed company, you know that they have a group chart, right? The holding company then have many subsidiaries. So sometimes when they have a new project, then they establish a new company to run a new project, right? If anything wrong, they just cut it off, right? And then the parent company will not be affected, at least will not be sued, right? So, number one, right? Don't think that you can sue the parent company because something wrong with subsidiary, right? No, forget it. Number two, the fact that two companies share common management, common director, common staff, common office, it doesn't mean that they are the same. Well, it always happens, right? Think about some of the law firms or some of the CPA firms. Take a look at the name page of their office, or some of the listed company, right? 有幾多水牌喺度? You know, in the receptions, right? So they list out all the company in this office. So sometimes there are over 100, right? So I have seen one more than 500. They list out all the company, then all the company registered in the same office, in the same unit, small unit, right? With only 10 staff here, but 200 company or 500 company, right? So they are sharing the same staff, the same premises, right? The same address. Even the same email, right? So everything, telephone number is still the same, and with common directors, right? So all the directors are the same person. But so what, right? Still, they are separate. So don't waste time to put forward an argument like this, right? Oh, come on, right? Take a look. They are using the same office, right? Come on. The three companies here, they are using the same office. They are having the same directors. So they are the same, right? They are the same. There are no difference, right? There are no difference. I can pierce the corporate veil, right? They are the same group of person. They are not separate company. Forget it, right? Forget it. Because there are so many cases. Some court already rejected this kind of argument, right? Okay. Then we have a question here that actually, under what kind of circumstances that we can actually pierce the corporate veil? So before I answer the questions, remember that, right? One thing. The concept of piercing the corporate veil is not something statutory. It means which is not based on a particular section in company ordinance, which is entirely a common law concept. Right? What I mean by common law concept is from cases. It's only a legal principle. So I can't tell you exactly under what kind of circumstances or what happened that I can be sure that you can argue on the principle of piercing the corporate veil. So I can only base on some previous cases that allowed by the court, right? You get my point here. Right? Because that is not statutory, this concept. Because some of the legal principles, some of the law, right? Some of the law, they are actually statutory. It means which is based on a particular section in the company ordinance. So in that kind of situation, the picture will be, clear, right? It will be easy to understand. But piercing corporate veil is not, which is entirely a common law concept based on cases, right? So I can only show you some cases, some previous cases allowed by the court to use, this argument to pierce the corporate veil. It means ignore the corporate form, right? So what are they? So what are the cases that once being allowed by the court? Piercing corporate veil, number one. Evasion of existing legal obligations. Right? So pay attention. Evasion and avoidance, they are legal terms. It means something in the law. For example, for taxation, right? For taxations, you can avoid tax, but you cannot evade tax. Evasion of tax is illegal, totally, right? But avoidance of tax is allowed. After seeking for advice from your accountants, from your lawyers, right? You can have tax planning in order to minimize your tax payment, right? That's tax avoidance. For tax evasion, it means you are creating some false documents, wrong statement, in order to mislead the IRD. And that's what we call evasion, right? So evasion normally is a negative term we use in law. So the number one is evasion of existing legal obligation. It means that you try to use a company and then to evade from some legal obligation you already have. Number one. Another one, fraud, right? Or PIN, right? Deception, something like deceptions. Number three, national securities. So in case of national security, some general rules in law will be ignored. The court will uphold national interests, right? Even in common law system. And the last one is statutes. It means under some sections in the law, not just in company law, right? Maybe in other ordinance, that the operation of that particular sections is having an effect of PSN Incorporated. All right? Maybe we have a break first, all right? We have a break for 15 minutes. Then after that, I try to explain to you all the cases related to PSN Incorporated, all right? We have a break for 15 minutes. So if you have any question you want to ask me, I prefer to ask me the questions after the class, unless it is urgent, right? Because I want to take a break, right? If it is urgent, you can talk to me. So otherwise, you can ask me after class. 誒 we back to class, right? So before the break, I told you that there's a very important concept. In order to combat the protections being given by the concept of separate legal entity, right? So we have a weapon here. So in case someone, some bad guys, they try to take advantage from the Solomon case, from the principle in Solomon case, then we can use a weapon that we call piercing corporate will. But the threshold is very high, it means that it's not easy. The court normally will be very reluctant to grant applications for you to pierce the corporate will, right? So only in some extreme circumstances. And you have to bear in mind that the concept of piercing corporate will is not based on statutes. It's not based on the particular sections in company ordinance, which is only a common law concept. It means based on cases. So I cannot tell you exactly. What happened, then you can use this weapon. And I can only show you some cases, right? Something being held by the court to be abused. Someone abused the corporate form, right? And then the corporate will being pierced. I can only show you some cases to help you to understand this weapon, right? This very useful weapon. So let's take a look of all the different cases here. We start from the number one, right? Number one, the first category. So something we call evasion of existing legal obligation. So property, right? Property. So this category, number one, is the most important one. So we always have questions, sometimes in the assignment and sometimes in the examinations, regarding the first category, right? So this case is very famous. So what happened here? The defendant, right? The defendant was once being employed by the company as a managing director in selling motor vehicles, right? So a person once worked as an employee, as a very senior staff, as a managing director of a company selling motor vehicles. And there was a restricted covenants in his employment contract. Do you know what I mean by restricted covenants or restricted clause? In saying that if you resign from this company, then you cannot work in the same professions for 6 months, 1 year, 2 years, right? That is quite common for very senior staff in a very small industry, right? For example, in Hong Kong, in Hong Kong there's, some guys, we call them the star tutors, right? They earn, I don't know, right, 5 million or 10 million annually, just as a teacher, right? So you know that I'm miserable by comparing with my salary, right? Much lower than that, I can tell you, right? I cannot tell you how exactly, how much I get paid, but I can tell you far lesser than $5 million. So otherwise, I quit my job as a lawyer, right? I work full-time as a teacher. So you know that there's some, famous, right, very famous tutors. They're helping the students take the public exam. They have a very handsome income, right? So in their contract, they have something we call restricted covenants. It means that if you resign from our tuition school, then you cannot work. You can no longer teach mathematics or history or English for 1 year, right? So that's what we call restricted covenants. So the managing director in this case, he signed an employment contract, and there was a restricted covenant in saying that you cannot work in the same industry after your resignations for several years, right? Okay. So this guy, right? I don't know, maybe he studied some law courses. So he learned about the Solomon case, and he tried to take advantage of it, right? So what he has done, he set up his own company to engage in the motor vehicle business. And he argued that by using the corporate form, but not himself in running the business, he can bypass the restrictions stated in his previous employment contract, right? Well, very simple, right? He tried to take advantage from the disarmament principle because he cited the employment contract with a restrictive covenant in saying that he can not work in the same industry after his resignations for, I don't remember, right, 1 or 2 years, right? That's not a real issue here, maybe 2 years. He he promised after his resignations, he's not going to work in the same industry for 2 years, right? So he learned about disarmament principle, and he understands that a company is in law different from the person who owned the company. So he owned this company, but he is not the company, right? So only this person, the ex-managing director, cited the employment contract, but not my company. So if I use my company to run the same business, and I'm the sole shareholder or I'm the controlling shareholders, then I can bypass the restriction. Is this argument convincing? Is it logical? Preliminary, yes. Right? Preliminary speaking, I agree, yes. When you think about the Solomon case again, the Solomon case held that clearly, if you own a company, if you incorporate a company, so once the company being incorporated, it is entirely different from the owners. So it existed independently, existing right, existing capacity, different capacity, right? Different right and capacities. So preliminary speaking, yes, right, yes, correct. But finally, the court disagreed, right? The court disagreed. Try to recall the very basic principle regarding Pearson Incorporated. But the court also held that there are 2 requirements here. So number 1, if you want to pierce the corporate veil, you have to prove to the court you set up the company with the sole purpose to cover up something, right? With the sole purpose. So the only purpose to set up your company is to cover something, because you don't really need the company. Think about it, right? If not because of the restricted covenant, this person is going to do the business by himself. So the company is actually not necessary. Then why this person established a company? And the only reason is that because you want to use the company to cover up something. So the first requirement being fulfilled, right? So how about second requirement? You have to what? You cover up something which is illegal, right? Not cover up something which is immoral. That's not a concern of the court, right? If you cover up your expenses with your secret lover, your secret girlfriend, it doesn't matter, because that's only a moral issue, right? It's not a legal issue. But this is a legal issue. Why? Because there is a contract here. So don't mix up illegal for criminal matters, right? Illegal doesn't mean criminal. Illegal means something against the law. Because you sign a contract, and that contract is absolutely binding. So you set up a company with a sole purpose to cover something, to cover up your primary motive in order to what? To bypass the restriction of a contract. That contract is perfectly legitimate, right? It's a contract which is binding, and you try to use a company to bypass the restriction of a contract that you already signed on it. So you are trying to evade from existing legal obligation because you're already under a legal obligation. So you set up a company, you try to evade from it. So the court disallowed. And the court allowed the original company, right? The company who employed this person before to sue him based on the concept of piercing the corporate veil. We look at the judgment here. The court considered the company was established because the defendant wanted to evade from his obligation in the restricted covenants. The court held that, right? Again, I call the judgment directly. So the company was being formed as a device in order to mask the effective carrying of a business of the defendant. So the company only being formed with one purpose, one purpose as a device, as a tool, to bypass the law. So the purpose was to try to enable him understand to engage in the business, which he feared that the plaintiff might object. So the only reason that you form the company is to defeat the law, right? You try to cover up legitimate purpose, and you want to defeat the law. You want to defeat the effect of contract law, right? So this is the first scenario that the court granted an order that you can use the principle, you can use this weapon in piercing the corporate veil, right? Which is number one. But you have to be very careful, because don't mix up evasions. I highlight in red, all right? I highlight in red here, the first paragraph. So don't mix up evasion of an existing legal obligation and liability, which has not yet occurred. What it means? It means that if you already under existing legal obligation, it means your obligation already here, right? You are being bound by something, for example, a contract, right? Or a contract. And then you set up a company in order to evade from it. That's not allowed. But if you want to set up a company in order to avoid something which not yet happened, I only worry about it. For example, risk, right? I know that when I set up a company, a limited company to sign contract, if anything wrong, then the third party can only sue my company, but not me. Nothing yet happened, right? I haven't yet signed any contract. I don't know what will happen in the future, but I worry about the future. I know that I'm going to run a business which is very risky. So I set up a company in order to protect myself. That is absolutely legitimate, right? And that will be allowed. So don't mix up. If your boss asks you a question, so whether a company can give you the protections regarding liability, so you have to, make sure one thing, this is the timing, right? If something already happened and then you try to set up a company to cover it up, and then you evade from it, no, right? You're still liable. But you set up a company in order to, avoid the risk in the future. Perfectly fine, right? Perfectly fine. So we take a look at the case in order to know the difference here. But very simple case, right? Very simple case. Something I already explained to you, actually. So a plaintiff in this case want to enforce an arbitration award. Do you know what was arbitration? 仲裁, right? Arbitration, we call ADR, Alternative Dispute Resolutions. It means sometimes when you have a dispute, when you have a conflict with the other party, you don't have to sue in court. Right? We can have something a little bit simple, right? A little bit more efficient. Another way to settle a problem we call arbitration, right? So later on when you study the module civil procedures, then you will know about what I mean by arbitration, right? So something like a court trial, but not exactly the same thing. So the plaintiff want to enforce an arbitration award. It means after arbitrations, one party won the case, right? So he get an award, something like the judgment from court. So he want to enforce it against the parent company. Why? Because the original party in the arbitrations was the subsidiary of a parent company. But that subsidiary company not capable to fulfill the arbitration award, right? For example, the arbitration award, saying that you have to pay $5 million as compensation. That company, not having enough cash. So I want to enforce that arbitration award against the parent company here. By arguing what? By arguing that, take a look at this company, right? This company is only doing one single business. So you set up this company because you want to evade from liability. So I want to pierce the corporate veil, and the parent company needs to sue me. But the court refused it. So what the difference between this case and the Guilford Motor case, right? This is the Guilford Motor case, right? So what the difference between the Guilford Motor case and this case? The court refused to pierce the corporate veil and held that the subsidiary was incorporated before the dispute. Very important. Timing, right? Yes, the judge agreed with the plaintiff, right? The company being set up to avoid risk, and that's the sole purpose in filing for a company. But you have to think about timing, right? The company being incorporated before the dispute. It means at that time, when the company set up a subsidiary, when the defendant set up a subsidiary, nothing wrong yet happened. So I set up a company not because I want to escape from any existing liabilities. Because I predict that, right? I know that there will be a risk in the future. So I want to have a company to protect my interests, and that is fine. You have the right to do so, right? And that's allowed, right? That's allowed. So it was not intended for evading an existing legal obligation, but for normal risk avoidance only. It is allowed in law, right? It means that's fine, perfectly fine, right? Perfectly fine, no problem with it. You can do so, right? You can do so. Even that's your sole purpose, right? Even that's your sole purpose. So I have a parent company here. I can use my parent company to run the business. But I intentionally establish a subsidiary, so only for this project, right? Only to sign this contract, but that's still fine. Provided that, right, at that time when you incorporate a company, the conflict not yet happened, right? The problem not yet happened, the liability not yet incurred, then you have the right to do so. We take a look at the judgment. Again, a very good judgment from Judge Bukhari. Do you know who is Judge Bukhari? He retired. Bao Jigang, right. He was famous because of his, yes, right. Amelia. She slapped on the police officer, right?
Yes.
Leave me alone. Right. I'm the niece of Judge Bukhari. Right? But anyway, he retired, right? Judge Bukhari. He retired. But he was a very good judge, right? Very good judge. So I call his judgment on this case, and it illustrated the principle clearly. So using the corporate structures to evade from existing legal obligation is objectionable. It means this is not allowed, right? That will be objected by the court. And the power to lift the corporate veil may be exercised. It means the court will exercise the power to pierce the corporate veil if you intended to incorporate company to evade from existing legal obligation. So the key word is existing legal obligation. On the other hand, to use a corporate structure to avoid the incurring of any legal obligations is not objectionable. It means that's fine, right? It's allowed. No problem with it. You can do so. Right? That's the corporate law, right? That's the common practice of the businessman. And the court power to lift the corporate veil does not exist. Very simple. So the key word, the key issues, right? One thing you have to tell, the difference between the two is timing. Right? Anything, if you're already under legal obligations, so don't be silly to form a company to evade from existing legal obligations, right? When you try to establish a company to cover up something, evade from legal obligation, that's not allowed. But if you set up a company only because you worry about something bad will happen in the future, and that's perfectly fine, right? Very important. So remember the judgment from Judge Bukhari, right? Okay, another example, Freud, or Pin, right? Something like deceptions. Well, I think this case is very simple, right? You can use common sense and you understand. The court will pierce the corporate veil for company used for fraud or illegal activities. So we have a case here, right? The Leung Yang case. So what happened? So there were two professors, right? Two professors. As I remember it from Hong Yu, right? Not Hong Yu Space, Hong Yu, right? Because in Hong Yu Space, we don't have a housing allowance. Right? That's very sad, right? only in real Hong Kong, not Hong Kong space. All right, so two professors, it doesn't matter, right, which university, just two professors, they claim for housing allowance from the university of their rental payment. Right? It's quite normal, right? Not just in the university, sometimes also in the government or in the big enterprise or a big company. For senior staff, you can claim for housing allowance. It means that, for example, if you pay 20,000 or 30,000 for your rent, the company will pay on behalf of you, right? To clear your rental payment, right? As a part of the benefit. Right? Sometimes they pay 50%, right? Sometimes they pay 100%, I don't know, right? But that's what we call the housing allowance. So the two professors, they have housing allowance from the university. It means that they show the tenancy agreement to the university. I'm paying 20,000, 25,000 every single month for my apartment. So the university pay them back, right? That's what we call housing allowance. But in fact, why am I in this case? So why this case trigger Pearson and Copper will? Because they rent the house from a company which was owned by the husband. Right? You know the tricky stuff here. So they rented an apartment, but that apartment owned by the company, and that company owned by the husband, right? Okay. I don't know whether they are law professor, right? But anyway, it seems like they know the corporate law. The parties argue that they did not own the house, but a company. And the company was a separate legal entity. Right? So they are against trying to take advantage from the Disarmament Principle. Is it true? Preliminary, yes, right? Preliminary, yes. Because of separate legal entity, the concept of separate legal entity. So who owned that property? Company, right? Not the husband. Okay, the company owned that property. And because of the Disarmament Principle, company and the shareholders, they are not the same. So even the husband owned the company, even own 100%, right? We already learned from the Solomon case. The court ruled that even you own 100%, but the company once incorporated, the company is separate from the owners, regardless of your ownership. So preliminary speaking, this argument is logical. I'm only saying that's logical, right? It's logical. But we know that the court will not allow such an argument. Even such an argument may be logical. Because you have to think about that, right? Think about it. Again, try to recall the basic requirements for Pearson Corporate will. Two things, right?
Yes. You
set up that company for sole purpose to cover up something. Number two, you want to cover up something illegitimate and illegal. Think about this case. It perfectly fulfilled the requirements. This company actually being served one purpose, right? So why you hold this company, why you hold this apartment? So why you pay the rent to the company, but not directly to yourself? So why you have this company? Because you don't need to have the company at all. If you just want to have that property, right? You don't need to have a company to hold it. So the only reason is you want to away from something. Number two, think about the purpose of housing allowance. The housing allowance intended to cover your expenses, right, as a benefit for the employee. So if you also own the property, it means that you are not actually having any expenses at all. Then it means that you're having additional payment, right, more than you should have it. So that is illegitimate and that's illegal. So in this case, the court rejected the argument from the two professors here, right? So the rationale is that the court regarded the whole plan was intended deceptions, and the company was merely a puppet in achieving an illegal purpose, right? So think about the whole thing, right? Think about the plan, the whole thing. So why you want to have a company like this? So why you have such a structure? By paying rent to a company owned by yourself, right? Do you have any legitimate reason to explain to the court why you have such an arrangement? You don't have. And the only explanation is that you try to take advantage from the Disarmament Principle and then to have, to get paid more than you're entitled with, right? So the court rejected these applications. And that is another scenario for Pearson Incorporated, right? Deceptions. Number 3, national security. So this case, 1916, what happened at that time? World War I, right? World War I. It's a long time ago. So during the World War I, Germany and the United Kingdom, they were fighting each other, right? In the First World War, right? So what happened in this case? The plaintiff is a company, right? The plaintiff is a contractual dispute, right? Contractual dispute. So the plaintiff is a company who delivers some goods to the defendant, right? But after that, the defendant refused to pay, right? So it's a very simple contractual dispute. But why this case trigger the concept of Pearson Incorporated? Because the plaintiff is a company owned entirely by the Germans, right? So all the owners, they are Germans. All the directors, they are Germans. So when the defendant failed to settle the payments, simple, of course, the plaintiff sue on it, right? I already delivered the goods to you. You're supposed to pay. So if you are not paying me, I sue you in court based on breach of contract. But there's a very special defense being raised by the defendant, right? Something quite tricky. The defendant argued that you are enemy, right? And you are national enemy. Because at that time, United Kingdom was at war with Germany, right? And think about this company being owned by the Germans. So you are the enemy. So I don't have to pay you, right? Because the contract is not valid. I think of example in Hong Kong, very long time ago, if you're old enough, I heard from my uncles, right? I'm still young, right? In early 1980, when United Kingdom was at war with Argentina over a small island in Atlantic Oceans, the Falkland, right?
Yes.
Falkland. So at that time, Hong Kong was still a colony of the United Kingdom, right? So when United Kingdom was at war with Argentina, suppose Hong Kong was also in the same status, because at that time, Hong Kong regarded as a part of the territory of United Kingdom. So all the bank account in Hong Kong, right, all the assets of the Argentina government being frozen, right, and all the contracts signed with the government there, with Hong Kong, with any companies in Hong Kong, entirely not enforceable, because the United Kingdom not recognize the legality for all the contract, all the right of the enemy, right? But they are at war, right? They are at war. So there's something happened in this case, just like in this case. So that's the argument of that defendant, right? I don't have to pay. You cannot sue me because you don't have any right to enforce a contract because you are an enemy, right? Because they are national enemy. And then think about it, right? Think about it. If you are the plaintiff, if you are the lawyer of the plaintiff, right? If you're a lawyer of the plaintiff, or if you are the plaintiff, right? You're the owner, you're the Germans, right? You're the Germans. So you are the shareholders, but you are the Germans. What will be your argument in court, in the British court? You also learn that of the Disarmament Principle, right? At that time, the Disarmament Principle already existed. So the owners, the Germans, they try to take advantage from the Disarmament Principle in arguing that, come on, think about it. The owners and the company, they are not the same. That company, remember one thing. That company, the plaintiff is a company, right? It's a company registered in England. So it was a British company, right? Company, we have a concept, something we call the domicile, right? Domicile, 即係法律嗰個註冊地. It means your legal identity, right? we call it domicile, legal identity. So it depends on where you register your company. If you register your company in UK, then you are a UK company, right? If you register in China, there's a Chinese company. If you register in US, the US company, right? Something like that, domicile. So the lawyers of the plaintiff, for the Germans, they argue that, right, I agree, all the owners, they are Germans. And Germany, at that time, was at war with the United Kingdom, but because of the Disarmament Principle, the company and the owners, they are not the same. And the company are being registered, incorporated in England, right? So the company was a British company. So the defense raised by the defendant was not actually valid, right? So how to think of it? We look at the second paragraph. The court held that the domicile of a company was normally determined by a place of registrations, right? Correct. So the court agreed with the argument of the German company, with the plaintiff. Yes, I agree with you. Where you register a company, that will equivalent to the domicile, right? To the legal status. So preliminary speaking, the plaintiff was a British company, right? Preliminary speaking, correct, right? Correct. Because of the Disarmament Principle. Because of the general rules in company ordinance. So where you do the registration, then that company belongs to that jurisdiction. But because of the case of national emergency, the court would consider the actual ownership. And since the Germans control the company in wartime, so this company shall be regarded as an enemy. So the court ignored the general principle of Solomon case in terms of national interest, right? So the only reason that the court refused to uphold the Solomon principle is entirely on national interest, not because that's just to do so. You think about this case, the Germans, the company owned by Germans, they deliver the goods to the British company, which is perfectly legitimate, right? I deliver goods to you, entitled to get the payment. Nothing wrong, right? But the court still, right, disallowed the application of the German company just because of national interest, right? That's overwhelming because you are enemy, right? If you are enemy, you don't have any right in my country, right? Because we are at war, and that's all, right? So you have to be careful, right? You have to be careful because when national interest being involved, so sometimes the general rules, the general commercial rules will be ignored, right? It doesn't care, right? So think about the case of Huawei in the US, right? So think about the real issue. It's politics, right? Something like that. So national interest is something overwhelming, and we have to be careful, right? We have to be careful. And apart from that, apart from all the cases, right? Apart from all the cases, so sometimes there are some statutes, and there are some ordinance that the operation of this ordinance, they are actually having the effect of piercing and copyright, right? It means that they are not a section in saying that this section being legislated for piercing and copyright, no, right? But the effect, right? The effect of these sections, of certain provisions in the law, the effect actually like piercing the copyright. For example, right? I'll give you one example. There are many different examples, but I'll give you one of it. So section 275 of the company winding up and miscellaneous provision, category 2. Do you remember that we have two company ordinances still in force, right? The dual regime. So normally 95% of everything being covered by the new company ordinance, which is Cap 622. But there are two areas of law still belong to the old company ordinance, which is winding up, right? Sublot, right? Winding up, liquidations and prospectus. So this area regarding winding up, so still belong to the old company ordinance. So anyway, it doesn't matter. The law states that whether the director should have known that there was no prospect of avoiding insolvent, but nevertheless continue to trade without taking steps to minimize the losses to creditors, shall be personally liable for the company debts. So any of you still remember the case of California?
not the California in the United States, I mean the fitness center in Hong Kong, right? Do you remember we have a fitness center in Hong Kong, California? That company liquidated, right? The business already collapsed. A lot of complaints from the customers, right? A lot of grievances, because they pay a lot, right? They have a very tricky plan. They ask you to prepay your training plan, right? Something like that. You prepay for the coming 10 years, then you enjoy 50%. I think this is nonsense, right? Why someone prepay for the coming 10 years, right? But that really happened, right? But they have very handsome guys as a salesman. They have very hot, pretty girls as a salesman, right? So people get confused. Right? They don't know what they decided on, right? So it really happened. The customer, they prepay the coming 10 years training plan. So it involves 100,000, more than 100,000, right? 10 億萬, I don't know. All right, but that's not a real issue. Some of the directors are being arrested. If you still remember the news at that time, around 2 years ago, 2 or 3 years ago, right? So some of the directors, they were being arrested by the police in this case, right? So my mom asked me a question. So they were being arrested because they have a failing business, because they are losing money, right? No, that's wrong, right? Of course not. So you will not, that's too harsh. If you are directors and you are not capable to make a profit and you lose money, then you will be arrested, right? So who will be a director? So who is going to invest? It means the law disallow anyone to lose money, right? When you form a company, you have to make a profit. That's nonsense, right? So otherwise, I will, a death sentence, right? It's nonsense, right? So why the directors were being arrested? Of course, not because California, the fitness center, failed to survive, right? No, not because of it. For what? You think about same paragraph. Look at it again. All right, look at it again. Because the law states that if you are a director of a company, right? If you're a director of a company, you understand that your company is not capable to survive, but you still commit your company for any obligations more than the period for survival, then you will be personally liable for everything. That may be criminal or civil, right? Personally liable. Then you think about the fitness center. Because they are directors, so they have the right to check the bank account for the financial statements. So the directors, the management, they understand that the company cannot survive for more than 3 months regarding the cash flow. All right? Cash flow, I'm not talking about profit. Right? If you have accounting concept, you understand what I'm saying. Right? If your company is not making profit, maybe it doesn't matter. If your company is losing, it doesn't matter, but it's only an accounting concept. Right? So survival depends on cash flow. It means you don't have enough cash to settle the minimum payment for surviving, right? To pay your staff, to pay the rent, right? To pay the fees of the electricity or, all the miscellaneous expenses, right? That's what we call about survival. So if you understand that your company, you are not having enough cash to survive for 3 months, but you commit your salesman, you commit your company for contract, for an obligation, which lasts for 3 or 4 years, right? So that will be a problem. And you have to be personally liable for it, both civil and criminal obligation, right? And then think about the nature of these sections. And think about the nature of this law. It's something like Pearson Incorporated. Why? Because normally, as a director, right? Well, think about who signed the contract. The company signed the contract with the customers to provide training plan for the customer for the coming 5 or 10 years, right? So that's a contract between a company and customer, not a contract between directors and customer. So, suppose the liability belongs to the company. But because of this section, right, the section states that if you already learned that, if you fully understand your company cannot survive, but you still commit your company for a contract which lasts for 10 years, then you will be personally liable for it. Then think about the effect. It's actually like piercing the corporate veil. Do you get my point here? All right? So there are other examples, but we don't have time to talk about all of them. Right? I'll give you one example here. So we look at the last paragraph. When director understands the company is in financial difficulty, he should not let it to keep incurring further debts. So otherwise, he may be personally liable for the debts incurred by a company. And the effect, right? Think about the effect. It's actually like Pearson Corporate, right? So this is the last example, all right? Okay, so that's all about Pearson Corporate and the principle and the Solomon Principle, right? But that's not yet the end of our lecture. Because one thing we have to learn, something we call promoter and Incorporation Contract, right? One more thing before we end the lecture for today. So what is that? Right? What is it? So what is promoter and Incorporation Contract? So think about that. Right, think about that. Before the incorporation of a company, so someone sometime need to be responsible for the incorporation formalities. Well, you only incorporate a very small company, right? Small company with one shareholder, without any transactions. Or if you incorporate a company just to hold asset for tax purpose, then probably I don't think you need to have a promoter, right? You don't need anyone to do a lot of formalities because you can do it within a few hours, or you can just simply instruct your lawyer, right? Or the CPA firm to do all the work. But if you really think about, if you establish a public company, right? Or a private company which involves substantial transactions, it means a lot of money being involved in, right? Real business, we are talking about real business, real transaction. So sometimes before the incorporation of a company, you already instructed someone to do a lot of work, right? To do a lot of work. It includes all kinds of registration, fundraising, and contract negotiations. If you want to establish a company, and you want some very wealthy investor to be a shareholder, then you have to prove to the investors, say like, I already have a contract with Mr. Lee Gasing, right? Even the company not yet incorporated, but because I try to persuade the investor, right? They want to join the company later. So I try to persuade them, well, come on, right? Take a look. I already signed a contract, right? Or at least orally, Mr. Lee Gasing agreed to invest in my company, right? Even not yet incorporated. Jack Ma already agreed to invest in my company. Tencent, right? Already agreed. Tangshan already agreed to invest in my company. Microsoft already agreed to invest in my company. I just had the dinner with Bill Gates, right? So you want to persuade investors in your future company. So sometimes you have to do something first before the incorporation, right? Okay, so that person in doing this kind of work, we call him as promoter, right? Promoter. So this person being called as promoter. And any contract intended to be signed on behalf of the company before incorporation, we call this kind of contract as P-incorporation contract, all right? So that's something we need to learn because there are some legal issues involved in promoter and P-incorporation contract that we have to understand. So take a look at the definition of a promoter. Do we have a definition of promoter? Yes or no? Yes or no? And the answer is yes and no. Why? Because the company ordinance itself does not define promoter, right? So it means that if you check company ordinance, you can't find a definition here. So promoter is a common law concept, right? It's a common law concept. So we can only rely on the definition from cases. So let's take a look at the definition from cases. Any person arrange for someone to be a director, to pay shares, to negotiate preliminary agreements, to prepare prospectus, will be a promoter. Just common sense stuff, right? So it means someone responsible for, personal stuff, right? To pay shares, it means raising funds, and negotiate preliminary agreements, P-incorporation contract, right? So it means a person responsible for all the formalities, mainly on the business, right? Especially on P-incorporation contract, right? P-incorporation contract, very interesting concept in common law. It means you try to sign a contract on behalf of a future company, right? The company not yet existed, but you negotiating with Jack Ma, right, now here, or you are negotiating with Bill Gates, I'm going to form a company that Mr. Li Ka-shing is going to be one of the major shareholders, right? That company will be called Golden Egg Company, Golden Goose Company, right? But that company actually not yet incorporated, right? I'm just telling everyone I'm going to incorporate a company like this. So if we can sign a contract, first that will be good, right? Because if we sign a contract, if we already conclude a contract with Bill Gates, if we already conclude a contract with Jack Ma, so that would be very helpful for me to raise funds from the bank, right? Or to, that would be very helpful, right, from the business perspective. So sometimes you do this. But, so the definition is here, right, which is based on a case. Because we do not have a definition in company ordinance. So you have to bear in mind that a promoter, whether a person is a promoter, is always a question of facts depending on circumstances. Just like the case of partnership, right? Just like the case of partnerships. So unlike a company itself, right? Unlike a company itself, so a company being formed by registrations. So we have one thing which is a certificate of incorporation, which is conclusive evidence to prove the existence of a company. But for, say, like a partnership, right, we have to look for circumstances because we don't have one single conclusive evidence. And that's the same for promoter, right? Because we don't have a definition in company ordinance. We can only rely on common law. So it depends on cases. But normally, right, don't mix up promoter with company secretary or lawyer or accountant. They are professional in helping you to do all the paperwork, right? When you instruct a lawyer, normally solicitor, to help you do the documentation, or the accountant, the CPA, to help you to do all the documentation. They are not promoter, right? They are not promoter. So don't mix up their professional capacity. So what are the characteristics of a promoter? Number one, very important, right? Like, very interesting. A promoter is not an agent of the company. Well, actually, you have to think about, you still remember the definition of agent. A promoter should be an agent of the company. Why? Do you remember the definition of agent? Something we learned in lecture 1. Someone being appointed on behalf of the principal to negotiate contract for him. That person is an agent, right? Someone authorized to do something for the plaintiff. And then you think about the promoter, right? Think about promoter. Promoter actually helping a future company to sign contract or to negotiate contract. So you think about, the substance, right? The operation of the duties of that agent is perfectly like an agent. But the problem here is that a promoter is not an agent because the company does not exist. What means by promoter, right? Promoter means that a person helping a company not yet existed. So if a company already here, that person is not a promoter. That person is probably a director, right? So why we call that person as a promoter? Because the company not yet exists. So it means the principal is not here. You get my point here, right? Agency, you must have a principal. But where is the principal? The principal not yet existed. But the company not yet incorporated. So, no, right? Legal speaking, the promoter is not an agent. He works like an agent, but not agent anymore. So that's not based on agency law, but equity. Do you know the term equity? Is that something you learned from legal system, which is one of the sources of law in Hong Kong, right? Right? Equity. This is not common law, but some rules being followed by the court based on some English traditions, right? I don't have time to explain this, but something like that, right? So promoter is actually something based on equity. And promoter is a person who owns fiduciary duty to the company. He's promoted. Fiduciary duty, do you remember? Honesty, right? You always need to think about the best interest of your principal, right? Something like this. Okay, so we have a problem here regarding promoter, right? We have a problem here. We have a problem related to secret profit and conflict of interest of a promoter. Why? You have to think about the nature of his work. Right? Think about the nature of his work. And you have to understand the human nature, right? You have to understand the human nature. So the human nature somehow is not that good, right? Somehow it's not that good. Look at the first paragraph. But the company does not exist before incorporation, right? I told you already. So the promoter is the only person who can make decision. Is the only person who can make decision on behalf of the company. Because the company is not yet here. After the company being incorporated, we have, even you are director, but there are other directors to supervise you, and there are shareholders to supervise you, right? But because the company not yet exists, in the case of a promoter, right? If a company is here, there's no promoter. Remember the logic here. The company is here, no such person as a promoter. So if a promoter here, it means the company not yet incorporated. So it means that the promoter can do anything he likes on behalf of the company. Because no one is going to supervise the work if the company not yet exists, all right? Then we have a problem here. Number one, conflict of interest. The promoter may have the tendency, right, or may have the temptation to sell its own asset to the company at a price higher than the market value. So for example, if you have the authority to sign contract on behalf of a future company, and no one can check your contract, right, and no one can supervise your work, so I would try to sell rubbish to the company at a very high price in order to make a profit of it, right? So that's something tricky by the senior management of the listed company. Right? They're always trying to sell some rubbish to their own company or buy something expensive at a very low price from the company. Right? It always happens in this company. There's something we call corporate governance and other topics. Right? 公司管治. So number one, conflict of interest, because no one's going to supervise your firm. So you have temptation to sell rubbish to the company. Another problem, you may help the company to acquire some asset, right? Because that is your job as a promoter. But because no one's going to supervise your work, then you, again, you have the temptation to make a secret profit commission, right? To make a secret commission of it. Do you understand my point here, right? The promoter, whenever you have a promoter, then you always need to face the problem here. Because that's the nature of a promoter, right? Because whenever you have a promoter, it means the company is not yet here. And no one supervises the work of promoter. So we have to worry about conflict of interest and secret profit. So anything that we can resolve the problem. How do we solve the problem? So if I'm a promoter, right? So I sign a contract, I conclude a contract on behalf of the company. How to resolve the problem? One thing, and which is very important, or very simple actually, disclosure, right? Disclosures. By full disclosures, then you can resolve your problem, right? By full disclosures, it means you disclose everything after the company being incorporated. Then you'll be fine. But there's a requirement regarding the disclosures. You have to disclose to an independent board, right? Independent. So I'll show you a case here in order to understand this legal point. Someone bought a mine and then sold the company, where he was representing at a double price, right? It means he made profit from it, right? He made profit. So preliminarily speaking, something wrong, right? Something wrong. But he understands that he can rectify the problem by disclosures, right? So that may be fine, means if he fully discloses everything to the company when the company being incorporated. So he disclosed the whole thing to the board of directors. But pay attention to the composition of the board of directors. So there were 3 directors other than him, right? Other than, it means the promoter later on became one of the director, right? 佢成為咗其中一個董事 right? Promoter. And also became one of the director. So there were 3 other directors other than him, but 2 of them were under his control, right? 2 of them under his control, close friend or family members, right? It means under his control. So the board rectified, right? Affirmed the mines without raising any question at all. But the management later on changed it, right? It means the director changed it. and the new director decide to recover the purchase price and to rescind the contract, rescind something like cancel the contract, right? Rescind the contract, like cancel the contract. The management later on changed it, you mean the director changed it. They want to cancel the contract, right? On one thing, okay, fine, you disclosed everything to the board of directors after incorporation, right? You disclose everything. So, I mean, that's fine, right? That can validate your transactions. So that approval is valid, right? Validly approved it. But the management, the new management argued that. But the board at that time was under your control, right? The board was not independent. So that kind of approval was invalid. We look at the judgment from court. The court held that the person who established the company was a promoter. Simple, right? The law required that the sale made by a promoter to the company must be approved by an independent board. So approval can resolve the problem, but you have to make sure that the approval being done by independent board, right? It means that it's not under your control. So the board of directors who approved the transactions also under your control. The problem cannot be resolved because you are still the one in control of everything, right? And that's not allowed, all right? So not very difficult to understand. So what happened as a promoter if you breach of your fiduciary duties? So number one, you have to repay the profit, right? Simple, right? You have to repay the profit. If you make a secret profit, you have to repay to the company. And secondly, the company may also rescind the contract, rescind something like cancel, right? Invalidate. It means that even you signed a contract with third party, but the company can rescind the contract, cancel the contract. It means that you have to personally be responsible for it, right? You sign a contract on behalf of the company with Jack Ma, but the terms are unreasonable. So you cannot get Siri, right? You cannot get approval from the company. Then the company cancel that contract. Then you have to personally be responsible for it. So finally, the company may also have a remedy against the promoter for damages. Damages, in law, it means compensation, right? Damages, it means it's not damaging anything, right? Damages is a legal term, means compensation in contract law, right? 即係賠償咁解, right? So compensations. So the company can also sue the promoter for damages. So you can see that it is very burdensome towards a promoter because a promoter under fiduciary duty. And fiduciary duty is a very important term, very important legal concept in law, particularly in in company law, right? Fiduciary duty. So whenever you heard about someone saying fiduciary duty, then you have to be careful because it is a very burdensome requirement on you, right? Very burdensome. Not just being honest, but you always need to think about the best interest of your principal, right? The best interest of your principal. So as an employee, you don't have fiduciary duty to your employer. You don't have, right? You will never have fiduciary duty. You only have work duty. You only have work duty. What I mean by work duty means you have to do what being told by your employer, right? So if your employer asks you to clean the toilet, then you have to clean the toilet, right? But you don't need to think about the best interest of the company. But if you are the director or promoter, even you are being told to do something, you still need to think about whether that's for the best interest of the company. So if you are a director, if another director asks you to buy coffee, buy a latte from Starbucks, right? But you know that, well, actually you can buy latte from Pacific Coffee with even better quality for the lower price. Then you should buy from Pacific Coffee, but not Starbucks. And you cannot evade from your liability and saying that, well, I was being told to do so. No, because you are under fiduciary duty, right? Because you are director. But if you are just an employee, you don't have to worry about it, right? You only need to do what being instructed by your supervisor. Then you will be fine, right? But you, as an employee, you don't have fiduciary duty, right? So that is what we mean by fiduciary duty, very burdensome, right? So very special concept in law, in particular in company law. Okay, the last thing. I suppose you understand promoter and the problem faced by a promoter. You also need to understand pre-incorporation contract, right? So why we have a problem here? We have a problem here related to pre-incorporation contract. We look at the first paragraph. A promoter may be appointed to handle pre-incorporation contract. Fine, right? Simple, not difficult to understand. But we have a problem here. The problem is that a promoter cannot be regarded as an agent. Do you remember that I explained to you already, right? So the principle the point is, if you want to be an agent, you have to make sure that this is logic, right? This is logic. Where's your principle, right? If you want to be an agent, because an agent must be appointed by a principal. So you need to have principle first. So how to be an employee? You must have an employer first, right? You must have an employer. Employer existed, and employer, hire you, then you are the employee, right? So this is a simple logic. So if you want to be an agent, you must have principle. But then think about a promoter, right? Think about a promoter. If you are a promoter, it means the company not yet existed. So where is your principle? We don't have, right? We don't have. But you still need to sign contract on behalf of the company, right? Then we have problem here, the logic. The result is that we look at the last paragraph. The pre-incorporation contract is not binding on the company, strictly speaking, right? You can still do it, but you have to think about the consequence. The contract cited by the promoter may not be binding to the company. If the company not yet exists, and you are not agent, and the company cannot enforce it. So a very dreadful consequence will be the promoter may be personally liable on the pre-incorporation contract, right? So that's very risky work. So that's a problem of pre-incorporation contract, right? So how do we solve the problem here? I'll show you one case, right, before I tell you how to resolve the problem, right? I'll give you one case here to illustrate the problem here. So very simple case, right? So someone signed a contract to buy some boxes of wines on behalf of the company, right? As a promoter, right? As a promoter. So the company later on incorporated, but subsequently liquidated before the payment being made, right? Incorporated, but very soon liquidated before the payment being fully settled. So the promoter being sued by a supplier, right? Your company already liquidated, so you are the one to be responsible for it. But the promoter argued that the liability already passed to the company because the company incorporated, right? Company incorporated. I'm sorry, that argument not being accepted by court because the court held that, I highlight in red, right, which illustrates the problem here. A contract cited by one who professed to be signed as an agent, but who has no principal existing at that time, and the contract would be altogether inoperative, right? So that contract belongs to you, I'm sorry, right? And you have to be responsible for everything, right? For everything. So that's the dilemma in law, right? A dilemma in law. On the one hand, we need to have promoter, right? We need to have promoter because from the business perspective, someone need to do something before an incorporation, right? But because of the law of agents, because of the logic here, the principle is not yet here, and you cannot have agent. So if anything wrong, then the promoter will be personally liable. And who's going to be a promoter? No one's going to be a promoter, right? So how do we solve the problem? Yes, we can resolve the problem. So the problem can be resolved by two different ways. Number one, novation, right? Novation. What I mean by novations? Something like you create a new contract. There are two different ways for novation. Number one, right? You think about originally the third party, the contract with the promoter, right? With the promoter. So how to do novation? Number one, you cancel the original contract. Right? Both parties, you can do so. Contract can be canceled by mutual consent, right? If you can have mutual consent. And then the third party and the company, not the company, right? Not the promoter, to sign a contract with exactly the same terms, 100% same thing, right? And then to be concluded with the third party, between the third party and the company, then the problem solved. Right? Number one, right? Simple. It has nothing to do with the law, but just a practice, right? You don't need to have training in law. You can still do it. Simple, just a logic, right, to do something. Another way, right? Another way of novation. Another way of novations. Again, the third party and the promoter, right? And the promoter, they have a contract here, right? They have a contract here, but they execute an assignment, not your assignment, right? Not your homework. Right? It means they assign the right of this contract, right? They assign all the right and obligation of this contract to the company, right? To the company. The original contract remains here. You don't have to cancel this contract, but they sign one additional document. This thing is not a contract. This thing is something we call assignment, right? When you do conveyancing in buying properties, you will have a document we call assignment. Assignment, it means you assign your right and obligation to someone else, to delegate, right? We call that thing as assignment. That's not a contract, not exactly a contract. So when both parties sign an assignment to delegate all the right of the promoter to the company, then we don't have to cancel this contract. The contract is still here, right? But you have one additional document, which is the assignment, right? Then the problem can be solved. That is novation, right? That's novation. But apart from novations, something else. Because under the new company ordinance, the Cap 622, which enforced starting from 2014, right? So based on Section 122 of the new company ordinance, right? Section 122. Well, very simple. The law states that you have a contract purport to have made on behalf of the company before incorporation, right? If someone tries to sign a contract before incorporation, then that person shall be treated as an agent of the company. So now the law of statutory, backing, right, to someone, to the promoter. So don't worry about it, right? I know that I understand logic, but you don't have the principle, so you cannot be an agent. But because of Section 122, right? Section 122 states that person shall be treated as an agent of the company. Right? Don't worry, you have the law here, right? You have the law here. And after incorporation, the company may ratify the contract as the company had already been incorporated, and the contract was made by an unauthorized agent, right? It means that after incorporation, don't worry, right? The company can ratify, provided that you can ratify, right? Provided that you can have the ratification from the company, because you don't know, right? You just disclose everything to the company after incorporation, but you don't know whether the directors at that time, they are willing to ratify a contract. But provided that you are capable to do so, right? You are capable to do so, then you can rely on Section 122 to resolve your problem. Then you don't have to worry about, you have to be personally liable for the contract, right? Provided that you have the ratifications of the company, right? So these sections remedy the common law problem by recognizing the promoter as an agent of the company, not yet incorporated, right? So to resolve the legal dilemma, right? To resolve the legal dilemma, it means on the one hand we need to have promoter. We want to have a promoter, but on the other hand, the work of the promoter being troubled by the concept of agency law, right? Because that agent existed before the principal, and that promoter will be personally liable for the debt, right? So that's not sensible, right? So we have legislated a new law under the new company ordinance to resolve the problem, right? So provided that you have the ratification of a company, then you can be a promoter to sign a contract which is valid on behalf of the company, and you will not be personally liable for it, right? But provided that you can have the ratifications, that's not guaranteed, right? That's not guaranteed. Maybe the company is not willing to ratify a contract, and you still will be personally liable for it, right? But if the company is capable, they are willing to ratify a contract, then you will be fine. So the biggest advantage is that unlike novations, ratification does not require consent from the third party. Think about the two different ways to resolve the problem, right? If you try to resolve the problem by novation, you always, no matter in scenario 1 and scenario 2, you need the cooperation of the third party. In the first scenario, the third party willing to sign a new contract with the company, right? In the second scenario, the third party willing to sign an assignment to assign all the rent. So you need the cooperation of the third party. But for, if you are relying on section 122, you don't have, right? You can ignore the third party at all, provided that the promoter can secure, can have the approval of the company, then the problem can be solved, all right? Okay, so that's all for today, right? So see you again on Saturday or Thursday, all right? Thursday, Thursday, all right? So see you again, all right? So that's all.
係實上我頭先你話呢部咧話company嘅同 partnership 嗰啲嗰個嘅分別啫嘛。咁啊，大家即係 share 我明白啦。咁但 partnership 到有見到我寫快即係話我同你因為咁先算啦。咁阿邊明個 standard
冇 standard，
即係冇
standard， 沒有
冇 standard。
agreement 只係意思即係話，如果你能夠幫到個單船，係你哋同意，你哋想幫個單船，而嗰啲 element 係滿足到個 law 嘅要求，譬如話你係想做一個 one common business 啊，或者你係想 make a profit 啊。